but not to rush yourself and say, you know, I haven't done it, or compare yourself to other people who are much more advanced in their careers. No, just take it at your own pace, understand what your weaknesses are, identify them, and then know when you face it next time how to handle it. For instance, say that a client has come in today, she says the visa expires on 20th of August. Today's the 17th. Time is a problem. You haven't any documents. You haven't got the money. You've just told her how much your fees are. If you're done with the application, she has no leave to remain. And then Home Office is like, well, you had the client come into your office. Why didn't you put the application in time? So knowing that, advise the client, this is the steps to take. These are the steps to take. This is how you can take them. By this time, give me these documents and these are our fees. Consider it and give me instructions by this time. Communicate it well, clearly, and be in control of how you want to proceed. But that comes through time, that comes through experience, and it will allow you to build more. But there's always more. You've never reached a pinnacle of mental well-being in the legal profession, because you would always come across situations on a regular basis that would challenge you mentally and professionally. But that's a good thing. That means that we're always progressing and progressing positively.
It's tempting, certainly as a lawyer, probably in all jobs, to try and put across that you're competent in all things and you're fast and you're efficient. If you come across like that at the start with a client, their expectation of you is going to be that the very complex legal matter that they've just brought to you, that has probably existed for a couple of years, unresolved, can be dealt with in 5 minutes, and you're only going to let them down. So I suppose in those circumstances I try and practice, I under-promise and over-perform, I suppose, to put it in a trite way, rather than over-promising and underperforming. So if I think I can have something done by tomorrow, and tomorrow is Wednesday, I will often tell the client, I'll have that to you by Friday, because that allows for the unforeseens. That allows for me finding something out in the transaction that is complicated, or intervening events, or other people, or conflicts, and then you meet your deadlines. And I think that helps with matters that you could otherwise see as being underperformance.
Well, it does, because I have to know my limits, and I have to be able to acknowledge and realise when I get to a point of potentially taking on too much work, and therefore identify when I have to outsource that work. So it's important that I know myself and my limitations, particularly emotionally and also physically as well, because I need to make sure I get plenty of rest to be able to get up the following day and deal with the challenges ahead. So it's really, for me, as a sole practitioner, to be able to identify when I need to call in someone else to assist me.
In terms of practical tips, I think one of the most important things is the ability to say no, and learning to say no, because it's through that you have the ability to be able to take control of your work and your work-life balance. Now, I speak from experience in relation to this, and it's something which I think often takes some time to learn. I, for my part, only learnt the ability to say no after about 8 years in practice. And I'll just say briefly how that came about. So as a junior barrister, and no doubt as with all junior barristers, I was anxious to do well, I was anxious to impress, to get new cases, get instructed on bigger cases, and I was working late, I was working weekends, every weekend. And one Friday evening, one of the senior members of Chambers came into my room and said, "What are you still doing here?" And I said, "Well, I've got this case for so-and-so and this case for so-and-so, and I've been working all weekend." And he just looked at me and he said, "This is madness. You're letting yourself down. The solicitors don't care, they just want the work turned round. And it's for you to decide how much you want to do. You don't need to do that many cases. And of course, as we all know at the bar, the worst thing you can do is do a case badly. So it's really important to do the work really well and to turn it round as requested, but you don't have to do every case. And once you've said no, what you then learn is actually people will wait for you. Not always, but often. And if they won't, well, there's no point doing the case in a rush because that is disadvantageous anyway. So I did learn to say no, and it is incredibly liberating because once you know you can say no and that people will actually wait for you, you realise that you can manage your diary and you can actually have your weekends, and it is so important. So that's my main and I think crucial practical tip is it's a really important way to be able to take control, and actually it takes some confidence to be able to say it, but once you've learned to say it, it really makes a difference to your life.
Particularly for junior lawyers at the junior end of the profession, they are more likely to be receiving work from several different work streams. They may have several different partners giving them work. So the individual has to take responsibility for workload from several different streams, and that high level of workload and the high turnover of work they're required to do can put a significant amount of pressure on individuals. Individuals need to be much clearer with their managers when they're being put under too much pressure, to have the confidence and the culture to be able to speak up, to say that they're feeling under pressure and that they need more support and resources to be able to meet the deadlines that they've been given.
I think criminal barristers' expectations of what they should deal with is quite it's quite unreasonable, what we expect ourselves to deal with and what we expect other people to deal with. So I've had clients, I've had 2 occasions when a client has physically gone to attack me while I've been in a conference with them, but because I was young, I didn't want to make a fuss. The case was nearly over, the guy pleaded guilty, I just had to get through the sentencing hearing. I knew that if I withdrew, I wouldn't get paid for the case because that's the way legal aid works. I just put up with it and went back into a room on my own with him. And I look back on that and I think, what was I thinking? It's a process of always making these little decisions, and I think criminal barristers often take it on themselves to do the thing that makes life easier for everyone else, for the judge, for your client, for your lay client, for your professional client, for your clerks. If your clerks call with another case and they say, "Can you take this case on?" You want to help out. You want to be seen as someone who's a high achiever, who has a can-do attitude, who can take anything that's thrown at them. And you do have to be like that to do the job. And there's a great sense of satisfaction that you get from getting to the end of that day, having handled a load of cases and done them well and done a good job for your clients. But on the other hand, it's extremely difficult to say no. And that has a very detrimental long-term, those little decisions, those little choices you make has a really significant impact on well-being, on the way you see yourself, your confidence,